Sync mark.
And we're on.
The other 9 are on Spotify if you want to look.
Good to go? Welcome to Divorce Cafe, the podcast where we demystify, detangle and hopefully detox the legal processes that follow a separation with the luminaries, the experts in the relationship property world. We are partners in law and friends in life. I'm Tina Henderson.
And I'm Shelley Fennell.
Today we examine the fraught world of breaking up when you're also in business together. If you've been watching Ted Lasso on Apple TV, you'll be familiar with the character Rebecca, who in her divorce takes over her husband's beloved football team, the only thing he ever loved, and sets about trying to destroy it. In the same way that custody battles can be devastating, a contest over an enterprise that you've built from scratch feels very personal, can be bitter, and when not handled well, can needlessly destroy assets. Here to talk about what can go wrong, what you can do when it does, and what you can do in advance to prevent a war of the roses, we have with us tonight.
Okay, so cue now, I'm ready. This is Thomas Biss. He is a hugely experienced commercial lawyer, director in our firm. He has been working on crises facing companies since the days of Equity Corp, without giving away your age. And speaking from personal experience, if you do what Thomas says, you'll be fine. You just need to work out how to get your emotions out of the way.
Stuart Henderson has had 50 years resolving disputes through mediation, negotiation and litigation, and while he is a trial lawyer through and through, I think he is still an optimist when it comes to his belief in people rising to the challenge of resolving their own disputes, with a little legal help of course. Thomas and Stuart, welcome to Divorce Cafe.
Nice to be here. Thank you.
Okay, we like to start with a little bit of an icebreaker. So are they both pulling one out of the bucket?
I think they can answer the same one.
Okay, so half of them are really sensible questions and the rest were basically made up by me. So let's just see where we get to. Who wants to pull it out?
Best breakup song ever.
Okay, that's me.
Elvis Costello's It's Been a Good Year for the Rose. Do listen, it's a great song, but it's a killer line, because I think what he's doing is responding to his ex reaching out to him after a breakup. And his only response is, how have you been? His only response is, well, it's been a good year for the roses. Great line.
Okay.
Great breakup song.
Thomas.
And I hate to, Elvis Costello is one of my subjects of excellence, and it's not actually written by him.
Oh, but he sings it.
He does sing it,
Yeah.
yeah. But it is, and it is a great song. But anyway, well, if you're going to do a breakup song, it's going to have to be Billy Connolly, D-I-V-O-R-C-E, which is.
Billy Connolly did that one.
He did, yeah.
D-I-V-O-R-C-E.
He does a version of that, yeah.
Oh, okay. Well, luckily you missed that because I sang. But but yeah, we'll try.
We could add C-A-F-E at the end of that song.
Yeah. Okay.
Okay, so the basics. So we always like to start with the basics so that we're all up to speed on today's topic. So Thomas, I'm going to start with you. How do people generally set up a business within a relationship, and what are the usual structures?
I would say that people don't think about a business so much in a relationship. It's just one of those things that more often evolves. So you end up with a company. For most people, that's what most businesses are in. If you're farming, for a lack of much thought, farmers for some reason end up in partnerships because no one else seems to use partnerships these days, old lawyers and farmers. And then you have some sole traders where you've got a tradesman, normally out your sparky or a builder, operating on their own account, and maybe they've got their wife doing the books at home.
So to you, Stuart, you're the litigator, the relationship property lawyer. How is a company classified in relationship property law? Who owns it when the parties separate?
A company that is formed for the purpose of the relationship or during the relationship whoever are the shareholders, it is relationship property. The shareholders who will be holding shares in an asset that is relationship property of the marriage. So if all the shares are in one person, or 99 are in one party and 1% in the other, it's relationship property, all of it. So the one shareholder, half of that share belongs to the other one, and the 99 shareholder, half of that belongs to the other person. The whole purpose of the Act was to treat the property that is accumulated in and for a relationship as property that needs to be shared, usually equally.
But from my perspective as a company lawyer, I don't care. From a company's perspective, it's who's on the register. So
Right.
on the register, it probably has said 99 shares for one party.
And the tax man.
And
presumably
the
as
tax
well.
man, the tax man probably doesn't care, just wants their tax.
Okay, but when they split, relationship property gets divided 50-50 unless there's one of the exceptions. So that's
Yeah.
that's how that
And
works.
so that, talking back to the structures, that tends to be quite a common scenario, isn't it? Where there's one partner, usually the male, would we say that?
Yeah.
That has
You
99...
Tell me off whenever
Yeah.
I'm dealing in genders.
Well, in my personal experience, 99 shares owned by the male, one by the female,
Yep.
because their accountant has said to set it up like that.
Yep.
Do you think that's
Yep.
the accountant that
That's,
says...
frequent.
and that's normally historical out
Yeah.
of, from a qualifying company, which is out of date now. But,
Okay.
yeah.
Yeah,
Anyway.
and the other thing is usually either both partners are a director or one partner is a director. That's kind of how it tends to go about, which has an effect on how things happen later.
It has an effect on the control, the immediate control, rather than the ownership.
Yeah,
Yeah,
cool.
Control and ownership. That's really good. We're going to go into those later, aren't we? The
yeah.
differences. Okay, so we'll go to the bits that we find interesting.
Yeah, this is what we find interesting.
We
It's
are
the name
nerds.
for
We
this
have to say
section.
that first. But to both of you, whoever answers first, what can go wrong when couples who are also in business together separate, and what are some of the really tough situations you see people dealing with?
What can go wrong?
Yeah.
Everything can go wrong. I mean, what happens is you start fighting, and so the company can end up, or the business can end up, unable to make a decision, unable to move, things not getting done, or things being done to spite someone, or you can end up without a clear purpose. You know, if a business is set up to make money, and suddenly it's become a vehicle to fight. And so, if you're not careful, that's where you end up litigating. You know, you can litigate in the family court, you can litigate in your business as well.
And once emotion and, it's not fair to say greed, but dollars are involved, then it's wide open for a really difficult situation. And I think the best answer I can give to your question is to talk about a case, and I'm mixing up the facts because it's a real case, or it's two real cases, right? And I'm doing what is always seems to me difficult. I was going to say the W word, but difficult in legislation, Party A and Party B, so that I'm not genderising it.
Good.
And it'll be more anonymous. Couple of businesses. Party A was the active businessman. Party B was a salaried worker, and they split up. And early on, there was some emails to and fro, some sensible proposals for division. There was some family members involved in the businesses, and it all fell apart. And I still don't recall what the trigger was, but suddenly, Party B, the salaried one, decided that that person had to. I'm struggling to avoid the gender. That person
Use he and she.
had to fix the other's wagon, and
Is that a euphemism?
yep.
Or an
But it's
actual
also
wagon.
literal, because one of the things that was done was that the business that was being run by Party B was successful, and he ran it quite well,
Just do he and she. It makes it easier to understand.
Okay, he ran it quite well. But she wanted to fix his wagon, froze the bank accounts after withdrawing all the money, bought a car, and eventually closed his business, essentially closed his business down. Freezing the bank accounts meant that he had to rush off to the bank manager and sort out a brief line of credit to keep things going, and it was chaos. Now, at that point, he consulted a lawyer, and what was started was first an attempt to use common sense and say, we can't go on like this, it's got to be sorted out, you need to do this, if you won't agree with anything, then it'll have to go to court, that's going to be expensive. And that's when emotion and money were heavily involved, and there was no resolving it. And the Property Relationship Act enabled him to make an application to transfer all the shares in the company, in their joint names, into his name. And the family court was capable of doing that to give him the control of the company, because the bank weren't interested in doing anything for him because he wasn't the sole director, he wasn't the majority, well, he wasn't the shareholder. And so the court, and at the end of the day, there was about 300K spent, and it's still not solved. The proceedings had to be started, an application for urgent treatment, and with courts, urgencies is a mixed bag, had to be filed to vest the shares so that he could rescue the business because it was rapidly turning into custard. And the court wouldn't make an immediate order. It took 3 months to get to the courtroom door. It took 3 months for Party B to consult a good lawyer, and it was only the courtroom door that led to an agreement that he could run the company. He got to the bank, he unfroze the account, he got it running, and after about 3 years it went through court, and there were several things that were really important. One thing that was really important was the common sense in the first endeavours to negotiate a sensible solution. The judge liked the common sense of the paper trail of attempts to get common sense, and it's a total mess. Now, I don't say that to you without suggesting an answer, and it may not have been there. Certainly we didn't get any agreement as to how to approach it, but mediation is what they too should have done. Somehow, whether by getting influential people to talk to them, somehow there needed to be a mediation with the two of them, looking at the long term, looking at the common sense, looking at the things that were going to go wrong, looking at the fact that they might still be fighting in 6 years, and have spent mega bucks on lawyers. And so that's where things can go wrong. You can go to court to get it solved, but the court's not going to deal with it quickly. You can't guarantee what the court's going to do, but it has the power to make sense out of those things. And the reason it was resolved at the courtroom door was because the other party's lawyer said, this is what the judge is going to do. And when I say it was a good lawyer, it was a good lawyer. She was experienced, she knew how the way courts would operate. So that client at that stage realised that the common sense thing to do was to leave the company in his hands. And that's what can go wrong.
So they were both directors?
Despite the best efforts.
Both directors at the beginning, and 50-50 shareholding or joint
I don't remember.
Joint shareholding.
Yeah, joint shareholding. And
so they should have got them at the stage where they were looking at sensible solutions and gone to the mediator then.
The thing that frustrates me, you say I'm an optimist, the thing that frustrates me is that that nothing worked to get common sense, and that's emotions, money, revenge, and control of the funds, payback for things I don't understand. It's just such a horrible situation, and things can go wrong. And all of the theories all of the plans I can come up with as we'll solve it this way, we'll solve it that way. The courts do have powers to solve it, but they won't move quickly. They won't move certainly, and somehow got to bring common sense to the situation, and mediation is the best answer that I know of.
Maybe if you'd sent the bill at the start.
What you can't get back, you can't avoid, is that you're dealing with people and relationships, and the best thing you can ever try and do is get people to understand their relationship and what they're trying to achieve. But sometimes what they're trying to achieve is pain.
Yeah, perceptions of fairness and about what you're getting in relation to other people, the other person can be a little skewed depending on where you're coming from,
Yeah.
and what information you have.
Okay, so you've touched on this a little bit, but what legal remedies? So say you've tried to work it out a little bit and you've hit a brick wall. What legal remedies are there to deal with what can happen? What are the most useful ones? Can you give us an example of when you might use a particular remedy?
So Stuart's talked about a key one there, which is where you're using the Relationship Property Act to force a transfer of shares, which gives control of the business, can continue on, and you can argue about the benefit of that later. So that's a really good outcome if you can get that, and that's allowed a business to continue. But if the reverse of that is to turn around and say, well, if we can't work together, we have to liquidate, and that's like the extreme ends of it. But liquidation isn't the worst outcome.
So
You appoint a liquidator to the company, and the liquidator starts spending money worse than lawyers do. But you laugh, but it's true.
It's justification.
But they spend money faster than lawyers, but they'll turn around and so they're going to wind up the company, and one of the things they can then do is sell it. Right, so they'll sell the business. So if one of you that then leads to one party can say, well, I'm going to buy the business from the liquidator. Now that's a little bit of a scorched earth policy, but if you can get to that point, you can take something. Liquidation's not always that easy to do, because if you have set yourself up in what I would normally recommend to two parties as a deadlock type situation, where if you've both got 50-50 control, then you can't necessarily liquidate because you've got to agree to do it. But then you can go to court and say there's and again, a court might turn around and say, well, I'm not going to do it. But all of those are options if you can put in front of court. We've tried this, we've tried that, this company has no future. You're needing to look at what the different levers that you can pull. Now, and I guess the thing you're talking about, there's a relationship, and that's between the parties, husband and wife, but there's actually a third person in the room. Maybe that was the problem as well. Maybe there's that was the problem to start with. But there's a fourth person. There's a third person in the room, which is the business. So the business exists as well. So if it's a company, a company is a legal person too. And so the company has some rights and some powers and some controls that you can look at. And it may be that the company owes money to, you're talking about that, it owes me some money, I'm going to demand that, and I'll take action against the company. But also the company has some remedies, and you might end up with someone who turns around and says, well, the directors have got duties to this company to act in good faith.
So just to give you a case study sort of thing, what if one of the directors goes feral and starts making decisions or taking actions that are clearly not in the best interest of the company? They have arguments with staff, they threaten to fire the best salesperson who just happens to be the best friend of their ex-partner. Maybe they start transferring money around.
They freeze bank accounts.
They freeze
bank accounts. They're doing things. They're refusing to pay the staff. They're refusing to pay the creditors. There's all sorts of stupidity that can happen. Now, at that point, you're damaging your business. You're causing that harm. Hopefully there's some rational thought. But if you then turn around, there are remedies against a director.
Replacing a director.
You can have
sometimes.
But all of that, I guess, gets you back to Stuart's point before, which is if you've needing to go to court, you're likely to be talking some time.
Yeah.
And even you probably would get something along the lines of some urgent injunctions to turn around and say we've got there's a range of shareholder remedies or company remedies for whether it's oppressive conduct by a shareholder or a director against the company or against a shareholder, or breach of directors' duties. There's a range of remedies that the company or a shareholder takes against the person doing the wrong.
But again, you've got to have a majority of shareholders or a majority of directors to bring certain claims. So it comes back to that. Do you really want to take a legal remedy?
And
what are the other remedies? What would you be suggesting?
Well, you've got to talk. You've got to get some. You've got to start to understand what's the consequence. What are you doing? You'd hope in a business, like in the family aspect of it, raising your children, how you deal with this, who's keeping the dog, those sorts of points. Those are emotional. Somewhere in there, you've got to get back to this as a business, and it exists for the purpose of making money. So you may and having there are the horror stories. More you do see people who can put it aside and continue to run a business because actually we've got the common intention. We want to make money,
Exactly.
and that goal can continue, and you can understand that. So if you're trying to communicate and get a consensus there, you're hoping for some rationality, and you can start to set up, in an ideal world, you'd have seen a couple set up a shareholders agreement. You don't see that very often, in all honesty, at the point at which a couple sets up a company. If there's just the two of them, they probably wouldn't do that. They're not
Is
expecting
that
to
because you're not getting advice to say
Yeah, probably,
this might go
and
wrong?
it's kind of difficult, and you're trying to say, well, what are you going to do when your husband runs off with someone else or whatever? How's it going to work? That's an odd conversation, which is in terms of the business. But you might, at the point at which you have split up and said, we're not actually in a position to separate this company now because, well, frankly, we don't have the money to pay each other out, or because actually we're both working and it's both our livelihoods. And if you can get the rationality of our best interests are to keep it going and to run the business, you could then set up that sort of shareholders arrangement.
Right. So you think it's possible to continue to run a business together after a separation?
And you've seen it, and I've certainly seen it. I can think of a number of examples of it where it works. Perhaps not long term, and it works perhaps until someone gets married again, or perhaps for a period of time, and you can set up some arrangements
So
that
what
say.
are those arrangements? So you're looking at arrangements that deal with what happens when we can't agree on an important decision, or
How are we going to do this? How are we going to manage payments? Do we have to both agree any payment out, or do we have to agree any payment over this, or how do we do payroll has to go each month, and we've got all those sorts of arrangements. We can set that
much
up,
are we each gonna
and
be
we're not.
paid?
I'm not going to take any money out, or you can put things out of temptation as well. You make sure that it's managed.
So would you go and sit down with a lawyer?
Yeah,
to do
probably yet another lawyer for the one for the business as well, and you can set that up. And everyone's got to want to do it, but it is for that purpose because you've got that goal. If you can get, and everything's about a relationship. We want to get the terms of our relationship. We don't want to live together anymore, but we do still want to make money. It doesn't. That maybe is optimistic. Stuart says he's an optimist.
I said he was an optimist.
Okay, yeah, you've got to have some optimism that and I think that
There's
it is
some
possible.
good reasons to make that work. Aren't there?
There is, and it isn't. It isn't as fundamental as how you raise your children.
Yeah.
But people can cooperate well over how they raise their children, and they can cooperate well about how they're going to run their business. And I've seen separation agreements, deeds of settlement of property, which have said we intend to continue in the business, and here's how we're going to handle it. And one of the clauses in that contract was, if we fall into dispute, here's how we're going to resolve the dispute. And quite often a really good dispute resolution clause, which says, for example, if something happens that we can't agree on, the first thing is that we'll try and agree. When we haven't agreed, then we will go to a mediator. And if that doesn't work, we will, and a whole series of things. And if you're at the stage where you've been running your business for a wee while and you've got a dispute and you think, how am I going to sort, the last thing I want to do is go through that rigmarole, and common sense prevails and they knuckle down and resolve it, because the alternative is just a nightmare, or potentially a nightmare.
Another thing that can go wrong in a relationship breakup is where there are some good and instant legal remedies that are worth taking are things like where both parties have been working in the business, maybe one is a bookkeeper or maybe they're paid housekeeping. They've got a shareholding so that some of the family expenses can essentially be run through the company. That's pretty common. But then, and so
there's no one from IRD here. No, that never happens. No.
Often, the next email that the person gets is an email telling them their services are no longer required, and their salary, shareholder salary, is going to stop being paid, or their wage. If they're living in a company-owned house, sometimes the animosity is such that they get a notice requiring them to move out. You can go to the court and say, I've got children, we were in this home, we need to be back in there. There's actually a case, Sing and Sing Farms, that talks about there was a husband, a wife and a father-in-law all involved in the company, and the husband and the father-in-law gave the wife notice that said, you're out. And she was able to go to court and get an order to say they were acting for an improper purpose. Directors have to act for proper purposes, and so the resolution they'd made to kick her out was invalid, and she was able to stay. She got an occupation order. If your salary's been stopped, you can file a PG, a personal grievance, sometimes for unjust dismissal.
And
you're employed by that company.
And employment law is one of the areas that moves faster in the courts than a lot of others. An employment grievance will normally you'll get to a mediation pretty quickly in an employment matter.
And sometimes you have a lot of annual leave.
Sometimes you have annual leave.
Sometimes you haven't taken
so
any
you can't
annual
have
leave.
it, businesses can't have it both ways. They have an employee who is an expense that they deduct, or they don't have an employee. If you have an employee, you can't dismiss them peremptorily.
And courts don't like it when you do one thing for one reason, like I'm just employing her because I've got tax efficiencies. Well, they say, no, you can't take the benefit and then not have to pay the price of having an employee. They're quite good in that respect, I think.
Yeah.
And that's employment law solving some of the problems, and the family courts are really good at making occupation orders to rescue those situations.
It happens quickly, like when you're talking about getting to the court door in 6 months, we're not talking about that with an occupation order, are we?
Or spousal maintenance. So spousal maintenance is the one where that cut off all your income and you've got kids and groceries and things like that. Spousal maintenance is another one where you can apply without notice, actually, with the right conditions.
My horror story in the months to get to the courtroom is truly a horror story. Most of those and one of the problems there was that there was a counter-attack that we had to acknowledge, so the judge wasn't prepared to make an instant order. But the courts are really good. The family court is really good at stepping in and making orders of occupation or vesting the tenancy in one of them. Had a situation once where there was a mortgagee sale coming up. She had arranged refinancing. And he wouldn't sign the documents, and so he really just wanted her kicked out by the mortgagee. He passive aggressive. He didn't want to be the one doing it, so he refused to pay the mortgage when the mortgagee sale was pending. She arranged alternative finance. He refused to sign the documents, and the court vested the property in her for the purposes of resolving this dispute, and she was then able to sign without needing his consent. So courts have got lots of good remedies for unravelling those difficult situations. Some of them, courts aren't up to doing it efficiently and quickly, but most times,
So one of the points Stuart touched on a bit there is one of the things you can also do is get other people to do your dirty work. And no one will do dirtier work than a bank.
Except for a lawyer.
So you can preempt a bank to do certain things as well by.
Well, that leads into the next question, which is what practical things can be done in the immediate aftermath of a separation to avoid destroying everything built up. And one of those, the things people worry about is we've got a $100,000 loan facility in the company, or there's $80,000 in the company bank account. What can you do? What would you recommend? I've separated. I think he's going to burn it to the ground.
What would you recommend? So I was busy saying you want to be sensible and rational and preserve value and all of that, but the quick advice you give is empty the bank account. It's a terrible thing to say, but it is one of those bits of advice people give because it's in your control. Then I'm not sure that it is right, but it is one of the bits of advice. But what
I usually say you can do that, but you're going to burn all of the trust, and you risk starting a domino fall that wouldn't have started.
You need to think about how you deal with it. You need to think about how the bank's going to react as well, and you can preempt the bank to close things down if you try hard enough and you say enough scary things to them.
Can you put you can put a limit on?
You can ask the bank to close accounts or to limit the accounts. There's a range of things. You're going to have authority to do that, and you won't necessarily have that depending on how things are set up. But again, as I say, if you've probably given guarantees, you can start to
give notices under guarantees, of course, because the guarantee, once you've given it, it keeps going until, in most cases, you can give notice so that future.
Yeah, and the bank, that'll be a condition of the bank's finance continuing, will be that the guarantee remains. Right. So the bank will then start to pull back, and you, depending on those are things that you really want to do carefully, because you don't want to have to pay all your money back to the bank, because it's normally not a convenient outcome.
Right.
But yeah, what Stuart's story was using the bank to force a mortgagee sale, right? That's not a smart move.
Because everybody's credit ratings are
everyone loses money, but on the other hand, if depending on who you're dealing with,
it's an immovable force.
You'll get something. Someone's waving a clock at us. Is that? Yep.
And you've got to be careful. Whatever you do, Tina's point, you've got to be careful what you do, because you may explode things, and approaching the bank and saying, I want this, I want that, will often lead, unless you've got two people duly authorised, often lead to the bank saying, well, I'm going to close all your accounts. I think you're a danger, and an unexpected outcome that might be devastating would occur. You've got to move carefully.
So again, talk.
Yep.
Find a way.
Hopefully.
Find a way to
find
talk.
your common ground.
Yeah, which is great in principle. I
It is.
I did have someone that they paid mortgage chicken or something, where she would put the money in just before the mortgage payment came out, but then he would try to take it out before the mortgage. I think in that case, I don't even know what to say to that, but maybe go and talk to the bank and say, can I pay it into a different account, because this isn't working.
Yep.
And you can have agreement to freeze the account except for regular payments, right?
Yeah.
The regular, Do you want to go on to
which question?
number 5, I think?
Number 5, okay. So what do you recommend doing when you start up a business to protect the company in the event of a separation? I think it's really interesting talking about where they're both directors, but that often isn't the scenario, is it? That you would have one director and the 99% shareholding.
Yeah, it's an interesting one. Like we see when a company, when a company's borrowing money, and we say a husband and wife, and the wife is probably guaranteeing it because she also owns the house, or the husband is guaranteeing it because and they may or may not have any idea what the business is actually doing that they're guaranteeing. That's the point at which we start to get nervous as lawyers. What can you do? In the perfect world, you'd be saying you should have some sort of shareholders agreement and agreement as to how this business is being run. In reality, I don't think that happens between husband and wife.
But it could do, right?
It could do.
How do we break a deadlock?
So we do prenups. We do a contracting out agreement. But I would say that I don't think it generally deals with running the business. It deals with the ownership of stuff, and it won't generally deal with it. I certainly see, if you talk about a larger business where there's maybe 4 or 5 owners, you sometimes will see there'll be arrangements in there that deal with taking shares away from an ex-partner, or stopping that happening, or some clawback arrangements. But I think in the reality of things, there's only so much you can do to manage that relationship.
What about a shareholders agreement?
Yeah, but you can, but I think it's...
In the common scenarios, you start off with not that many assets. You start a business together.
You don't want to
slowly
spend
you
$4
build
grand
it
on
up.
a
So at the
shareholders
beginning, you're just thinking, let's do this. Let's incorporate a company, and you're not actually saying I'm going to spend $1,000, $1,500 on a shareholder agreement, but in retrospect, $1,000, $1,500.
But I mean,
whatever you pay.
it may be, again,
Yeah.
probably more likely on a second relationship.
Yeah.
You'll see people
Exactly.
who've been through it once or
Yes.
twice. When they buy, if they buy a new business, they may set it up. Hindsight, burnt once, that's more.
Or
more
their
like,
parents have done it, and
Yeah.
their parents are telling them to.
Well, or you
go.
listen to this podcast
Yes.
and you see how wrong it could go, and you
Yeah.
think, well, what's the harm? It's like having a will, right?
Yeah.
It doesn't make you die.
I think it
As a
actually.
sales team, that's just awesome. I mean, we gotta have a will. It won't make you die.
You don't have to die. Yeah.
Are there any other issues that couples should know about if they're thinking of starting a company or business together? Any other issues that we haven't talked about?
No, I would have thought you. I mean, we've covered.
Let's go for it.
Yeah. I think there is a point somewhere in there. You say things go wrong, but that I mean, not every time, right? The rational outcomes, try to be rational, and trust in the fact that actually you ought to have a common purpose, and when you it's easier to reduce things to dollars in a business, and split them in half than it is to.
Yeah, you can argue about the dog.
The dog is slightly different, or whether you're what school you send the kids to is
Yeah.
much more complicated. A business really does just come down to money.
How do I break up with my business partner?
Text is the traditional way.
Change your Facebook.
The locks are changed. See you is a good one. I mean, I think
We're in business together, by the way, all of us.
Just get my phone out.
I think Paul Simon's advice was best. There must be 50 ways to leave your lover.
Yeah.
Slip out the back, Jack.
Yeah.
Making your plan, Stan.
But,
Sorry.
but seriously, if you're thinking about asking for a friend, if it's just not working, and you want to break up with your business partner, what's the best first step?
I think you need to say, well, hey, how are we? This isn't. I think you got to say, hey, I'm thinking about this. I'm not sure that this is working. I'm thinking about how we could deal with this, because it could be you're going to sell you could sell the business, you could sell the whole business,
Yep.
and again, very easy to split up the cash,
Yep.
right? Or you can say, look, I'm thinking of leaving, or are you thinking of leaving? Those are the really easy answers. One of you leaves or both of you leave. Then
Is leaving vendor fine?
yeah, but there's an arrangement in there. Yeah, it is.
You can
I
work
think
it out.
we can work it out. It's another song.
Another Beatles song.
So you can. I think you're not going to get there by text, right? You are going to have to talk,
Yeah.
and you're going to have to listen as well. It's not just talking. It's sometimes you got to listen.
The second to last, penultimate section, is quick fire question time. So you guys get 10 seconds to answer 10 questions, and we're going to alternate between you.
If you're thinking of separating, I'm going to go either one of you. What is your one top tip for something you can do to protect your company
If you're thinking of separating.
if you're thinking of separating?
Reach agreement with your partner.
Okay.
What is the difference, this is Thomas, what is the difference between a current liability and a non-current liability?
The current liability is payable within 12 months. It's an accounting question, not a legal one. But I'm
We
sure
don't
that's
give
right.
accounting advice.
Is
just
there an
for the
accountant in
record.
the
Go and
room?
ask
Is
your
there
own
an accountant in the
accountant.
room? Is that right? It is. Yep,
Yeah.
that's right. Yep.
Is that right? I don't even know if I can do the question
I'll
in
do
10
this one.
seconds. What?
Oh, true.
Okay,
Sorry.
do it.
No, you go.
You go. Which is
Hurry
the
up.
odd one out? The shares in a company started during a relationship. The family dog shares in a company started before the relationship, and a shareholder's current account balance.
The
Which
shares,
is the odd one out?
the shares before,
Yes.
because they're not relationship
Yes.
property.
Ooh,
Yes.
yeah.
Yay. He is a very good lawyer.
True or false? The phrase lifting the corporate veil means coming up with a great idea for a new business on your wedding night.
Yes, definitely true.
False.
No,
Yeah.
looking behind a company to find out who the shareholders are.
I feel like I
Right.
want to put this one to the audience, but we'll start with you guys. What are some signs you shouldn't be starting a business with your partner? Anyone?
Trust, really. If you
Lack of.
if you don't trust them,
It's a whirlwind relationship and you've only known them for 3 weeks.
yeah.
Don't start a business straight away.
You are both in business with family members. What is the secret to working and spending Christmases together?
You got to be a good cook, because like Christmas, you don't want to spend some time with someone who can't cook a turkey.
Being good people.
Being good people, gosh. But you can't pick your...
Respect, trust, and
Yeah.
faith. Really, I don't mean that in a religious sense. But you got to have trust, and I think it's all down to trust.
and benefit of the doubt, I think, as well.
Well, hopefully not having doubt.
We all have doubts, Thomas. Which is harder to raise together, children or the value of shares? Does it depend on the children?
Yeah, have you met? You've not really met my children.
I have met your children.
That one's going to take two.
You've met-
Children are harder in every way, shape, and form about absolutely everything. But
Okay.
creating value is not an easy thing either.
Is it better to have loved and lost a business than never to have loved it all? Does it depend on the business?
Depends on the business. You could lose a business and be quite happy, I'd have thought. I've seen plenty of people who thought they were in business and who are actually working for nothing. And I
Yeah.
think if you're working for a business the business is there to make money, and if it's not making money, then you shouldn't be in business.
Our last segment is called The Best Question Ever. We often focus on the nasty side of relationship disputes. But earlier this week, I spoke with a man working through the end of a long-term relationship who was referred to me because he was taking far less than his legally determined fair share. When I asked him why he would do that, he said, "It's just what I want to do. My main priority in this settlement is that my wife is well set up." The best question ever is, what is it that enables some people to come to a dispute with such humanity and grace when others don't? Just a light one.
Some people are better than others. I think that's true.
I think that's right.
Yeah, but I think sometimes the role of a lawyer is to help us be better, right? And like with hindsight, people can turn around and say, "Yeah, I didn't do the right thing there." And sometimes the job is for a lawyer is to say, "Actually, that's the wrong thing. You could do it, but you oughtn't to."
The most valuable part of my job is being able to work with someone, understand their problem, have them enough confidence in me for me to say, to guide them forward. So there's sort of education, there's confidence and trust between us, and being able to give the good. Actually, I've forgotten your question, but being able to give the good advice and have the matter move on. That's the most valuable thing.
I often say we go through relationship breakups or this and those sorts of things. We go through hundreds of them over the course of a year, and we get to say we've seen it before, and we say we know what happens next as lawyers. You know, we've done this more often, and I think one of the things, you can do that, but if you do that, this is what happens next. You know, if you say that to her, you're not going to get a good reaction. And if you do that, as you say, if you take all the cash out the account, you destroy trust. So this is what happens next. Is that what you really want? That's not the best outcome. And in business, it is easier to get to the dollars and to say the best outcome. The best outcome is this.
And some people are just not up to taking good advice at that time, sadly.
So that has been Divorce Cafe. Hope you've enjoyed it. Thank you to our guests, Stuart Henderson and Thomas Biss from Henderson Reeves. If you've enjoyed this episode, check out our other episodes on Spotify or Apple Podcasts and the other bits and pieces, articles you can find alongside it. See you next time.